If you're ready to embark on starting the estate planning process and you've got your initial consultation scheduled, here's how to make the most out of that initial estate planning consultation. Now, first of all, you need to share as much information as the attorney requests. The more information the attorney has at their disposal and leading up to or at the consultation, the better. There are many pitfalls, many different nuances, many areas of law that need to be navigated on top of family situations. So the attorney's going to need to know asset information and family information and what your wishes are. We have to lift up the hood on your investments, your cash, your real estate, your debts, business ownership. The more we can know, the better. Also, we do have to peer behind the curtain about family dynamics. We need to know if all the intended beneficiaries and family members, if they're healthy, if there's any sort of division among them, if we're anticipating any sort of contests, if there are any issues with trust of who will be the caretakers of finances, or for you if you're incapacitated. So because of that, the attorney is going to have to get to know you very personally. And if you're not willing to divulge some of those more safe-kept secrets, perhaps about family dynamics, net worth, things like that, it's not a good idea to engage that attorney. You're not going to get good advice or a good plan. The estate planning attorney can only devise a plan based on the information he or she knows. And so it does involve having the attorney get to know you, getting to know the more personal details of your life. Because of that, it is a good idea to make sure that you feel a sense of trust with your attorney. I try to meet with my clients one-on-one so that there is a private place for them to speak if they do need to divulge confidential information or information that they don't care to share with a lot of other people. That is information we need to know in order to give a good plan. The second thing you'd want to know is that you don't need to have all the answers. If you don't know exactly where you want your property to go upon your death, or exactly who you want to be your agents, your executors, or who you're going to designate to be in charge of managing your affairs, that's okay. You can still show up to the meeting and the attorney is there. We have plenty of experience and we have seen many different situations, so we can offer guidance in those areas that you aren't sure about. If you're worried about how to designate property to a problem child, how to avoid potential pitfalls and arguments, who you can trust the most to carry out your terms, the attorney can help you navigate through those areas. And even if you aren't 100% certain on the terms that you want, or you can't find agents or division that you're 100% satisfied with, even if you can't come to a full agreement on your distributions or your agents or specific terms of your documents, it's far better to have a plan that's enforceable and in writing that you're only 80% satisfied with than to have no plan at all. The attorney can be there to help guide you through that. So for one, find an attorney you trust and are comfortable with. 2, share as much information as possible that the attorney is requesting leading up to that consultation. 3, take your undecided issues to the attorney to get their guidance and recommendations about how to navigate the areas you're uncertain with.